Well, hello, everyone, and welcome to our webinar. I love that we do these. They're very informative and they definitely bring good information to our clients. And I'm sorry about the background noise, but that's my German Shepherd scratching behind my chair. Yeah. Anyways, 90 pounds in the corner. We try to do these on a regular basis. And as Romeo alluded to in one of his comments I saw, we would like to do these more frequently. Just because it's good for you all to have the knowledge. You know, we take care of the payroll and help you with your HR and your time labor management, but to have knowledge that you can have, at hand, especially when it comes to mitigating liability, which is a huge thing. It's important for us to bring that to you whenever we can. Romeo, I don't know if you're going to be doing a segment today, but hopefully he will bless us with some kind of information because he is the guru of all things payroll. But before we get started with Romeo, that's my British version of Romeo, I would like to introduce to you our keynote speaker, the star of the show, Stephen Parrish, spent over 25 years representing employers in all aspects of labor and employment law. Previously a partner of one of South Florida's prominent law firms, Mr. Parrish opened his office, Stephen M. Parrish, PA, in 2011 to provide highly responsive, personalized, and cost-effective legal services to as many clients. Okay, let's just look at that. Highly responsive in an attorney, that right there is an A+. Personalized, unheard of, and cost-effective, we have found ourselves a gem, people. His focus is always on making the law work to help your business, not cripple it through the legal process. So with no further ado, Mr. Parrish, it's all yours.
And by the way, cost effective is all relative, right? If you compare it to other lawyers.
You're killing me. I'm trying to give you props.
I know.
Okay.
Anyway, thank you very much. Good afternoon, good morning. If for those of us that aren't on the East Coast, and I'm glad to be here and talk about these two final rules. One of which is going to be effective next week. At least part of it. The first aspects of it will be effective next week. So, as Rhonda said, I'm a labor and employment lawyer. I represent employers. I don't represent employees. Big part of my practice is trying to keep my clients out of trouble with compliance issues, difficult situations. But if they do get in trouble with a claim, I define trouble as a claim has been filed. I will try to help them resolve that and defend that claim. And so today we're going to talk about the two kind of hot rules in my world, Department of Labor rules that increase the salary thresholds for the white collar overtime exemptions. And then we're also going to talk about the Federal Trade Commission final rule, which is attempting to ban post-employment non-compete clauses. That rule is scheduled to be effective September 4th. The Department of Labor rule goes into effect July 1, and then there are steps where it goes. The threshold increases more on January 1, and then every 3 years after. Both of these rules there is litigation. I'm sure we've all read about. The Department of Labor Secretary has been sued. The Federal Trade Commission has been sued. There are active cases where industry groups, employers are attempting to enjoin both of these federal agencies from enforcing these rules, enjoin these rules from ever taking effect. So keep that in mind, and we'll talk through some of that. But let's get into the Department of Labor because we're cramming a lot here into this hour. I'm going to try to allow for hopefully some questions after each of the sections. So if you have questions, I guess I'll hear about those when I'm done. But
Stephen, I just put in the notes to everybody if they have any questions, so please put them in the notes. And if you don't know how to enter the notes, there's a little notes section to the right, and you can enter your note there. Sorry.
Okay, no problem. So we'll talk about the Department of Labor final rule, and just a little refresher. We're talking about the Fair Labor Standards Act, which governs overtime and minimum wage compensation. And in particular, today we're talking about the white collar exemptions which are also called the executive, administrative, professional exemptions. And those are defined by the Department of Labor, and they exempt employees, those exemptions exempt employees from the Fair Labor Standards Act, overtime, and minimum wage provisions. We refer to it in here, and we also refer to them as the EAP exemptions, but we're not talking about other exemptions. We're focused on these particular exemptions today. So general rules on the white collar exemptions. You're paid on a salary basis. The exempt employee is paid on a salary basis. There's a couple of exceptions for medical professionals, for legal professionals, but for the most part, you have to receive a salary. That salary has to be at least $684 a week, or $35,568 per year. That's the current salary level in effect as of today. And to be exempt, and this is really the most important part of the exemption usually, to be exempt, you have to satisfy the primary duty test that the Department of Labor has set. And that primary duty test is not met by a lot of employees who are paid a salary at lower levels in that $35,000, $40,000 range. But sometimes it is. If it is, usually it's going to be somebody who's supervising 2 or more employees, or somebody who's a beginner professional, like maybe in the accounting world, who has a 4-year degree and they're doing something. They're working in an area that uses that degree. And there's also the highly compensated employee exemption. That exemption relaxes the duties test for employees who are earning presently at least $107,432 a year. And that $107,432 is total comp, as long as they're also earning that minimum salary of $684 a week. So just a little disclaimer, as always, lawyers, we have to disclaim stuff. We're focused on the Fair Labor Standards Act today. We're not focused on state law variations. If anybody here is in California, as you know, you have a robust wage and hour law that you have to comply with, as well as the Fair Labor Standards Act. And various states have, some states have, I guess, more robust laws than others, but every state touches in the areas of minimum wage and overtime. But just keep in mind that salary level can be higher in certain states, and I've referenced California, Colorado, New York, Washington. Different states can have for different duties tests for exemptions, and different states, some states don't recognize the Department of Labor's exemptions. And I'm primarily focused on California there, but we're here today on the Fair Labor Standards Act. So what are the Department of Labor's changes in the final rule? Really, their focus is on having higher salary levels for those white collar exemptions, and also having automatic increases every 3 years that go into effect. And their goal, quite simply, is to make more employees overtime eligible. They raised the threshold, the salary threshold, so more and more people are going to be able to receive overtime, because some employers financially are not going to increase their pay to get past those thresholds. It's a financial decision. So here's the numbers. Effective next week on Monday, salary threshold is going to increase $160 to $844 per week, and that equates to just under $44,000 per year. And then very quickly, time flies, in 6 months, January 1st, 2025, salary threshold is going to go make a pretty sizable jump from the 35,600 that we're at today to $58,656 and $1,128 per week. And so those numbers, and then I'd say thereafter, salary is going to increase Department of Labor is going to increase the salary threshold every 3 years, and that starts 3 years from Monday. So the next change would be July 1st, 2027. So, and then on the highly compensated employee exemption, July 1, it's going to 132,964. That's up from 107,000 and change. So that's a good jump. And then January 1st, 2025, it's going to be 151. So you're going in 6 months from 107,000 and change minimum to satisfy that exemption to now, almost, you know, $40,000+ more per year to qualify for that exemption. And then again, every 3 years, they're going to change that. So there are multiple lawsuits challenging the implementation of the final rule, and those lawsuits, the goal of those lawsuits is to enjoin the Department of Labor from enforcing this rule. It's to stop the rule in its tracks before it becomes effective. And we can, a lot of us will remember back in 2016, there was a very, very similar rule. Lawsuit was filed in Texas, where in the same jurisdiction where there's a pending lawsuit for this rule that we're talking about today. And ultimately that rule, about 2 or 3 days after it took effect, Texas judge enjoined the Department of Labor from enforcing it. So we're really in the same posture. This rule is they've done things a little differently with the step up, but ultimately the jump that starts, the salary threshold jump in January next year is actually a lot more than what the Department of Labor was trying to do back in 2016. But again, those rules didn't go into effect. Some employers made the changes. They communicated raises to their employees, and then what do? Do they take back the raise? Some of them did, but most of them let the employees keep the raise. But the point is it's that there's a financial consequence to bringing people's salaries up. Obviously, there's a financial impact if you want to keep them exempt. So what do we do now? So you've got 6 days, right? And you have a little more time because that paycheck covering July 1st isn't going to go out, on July 1st, right? So you have a little bit of time, a week or so. But if you have exempt employees who are earning less than the 4388, or you have highly compensated employees who you've exempted because they were making 107,000, but they're earning less than the roughly 133,000 that goes into effect July 1, you want to look at them, and you want to, and I would say the first thing you do is as you're looking at the financial issue, first thing you should do is decide, are they exempt or not? Is the classification what I've termed here as low risk, high risk, or gray area? I would define like a low risk as somebody who's earning under the 4388, but they're supervising 2 or more employees. They have hiring, firing authority, or they make recommendations that your company generally follows. Those people are probably, could be exempt, and so it's a lower risk. I mean, they're fitting the duties test pretty well. But if you have like administrative employees who are you're classifying them as exempt under the administrative exemption, they're performing clerical type work and they don't make critical decisions, or they might recommend a decision, but they have to go to somebody who actually makes the decision. Those would be an example of a high risk area. And maybe in those situations where you're high risk or in that gray area, you might want to consider just reclassifying them to non-exempt. And their pay can more or less stay the same. You might have to do a little bit of math, and we'll talk about that. There's some things to consider if you're going to reclassify someone. And I always put this first bullet point because there are morale issues. Like people like being salaried. They like being part of the exempt team. Maybe they're moving up in the company, and so there could be morale issues about a loss of status. So you've got to be sensitive to that and communicate effectively about that if you are going to make a change. If you're converting them, you can continue to pay the salary. You don't have to convert them to hourly, although you could. And whether you keep that salary or you convert them to hourly, it's going to depend on their regular work schedule, right? If they regularly work 40 hours a week and they really don't work overtime, which happens a lot, keep the salary in place. Or you can convert them to hourly if that's what you want to do, either way, but you do avoid some of those morale issues, some of that negative impact. People like their salaries. That doesn't mean they don't want to get overtime if they're entitled to it, but they like being paid a salary because they know what they're getting during that week. What you do have to do is, if you don't have a time recording system in place for these individuals, you need to put one in place. And maybe, again, you keep it simple and you have them do a timesheet and sign off on a timesheet. Maybe, there's some way you can do it where they're not punching a time clock if that's an issue, but you can also just have them punch a time clock. And then, just like any non-exempt employee, you're going to manage their overtime hours. Now, going back, when you're converting salary or converting to hourly, if you have somebody who's working a lot of overtime, then, on a regular basis, like they're normally scheduled to work 50 hours a week, you're not going to take their salary and divide it by 40. You're going to do some math and come up with an hourly rate or a revised salary that accounts for the overtime that they're going to be working, right? So, but if you have somebody who is generally working 40 hours a week, you're going to manage or limit their overtime. And then you're going to pay overtime in the weeks where it's worked. And depending on how far away an employee is from that threshold, the minimum threshold of 43,888, it might be cheaper to pay overtime for the company. Then cheaper than increasing their salary. So, and then again, you're going to communicate. The employees, a lot of employees are aware of these rules. There's a lot of press over them. We're in this political year where there's news stories to communicate, how the positive impact this will have on workers. There's less on the negative impact it has on employers, and the game that's played. So you're going to communicate effectively with impacted employees and let them know that this is a change in the law and you've got to comply. If you do have people under that threshold and you're going to continue to classify them exempt, then understand that the new rule does allow you to use 10% of that 43,888, which is 4,389. That 4,389 can come from non-discretionary income, such as commissions, non-discretionary incentive pay. And so there may be a way for you to come up with something where you don't have to increase a whole lot, at least on this first go around on July 1. But you can incentivize people, and maybe that has a positive impact on operations. So that is a change. That is a change in the current law. The current salary thresholds don't allow for that 10%. So that's next week's, which is dealing with a smaller increase, right? $160 more a week if you're on the low end of that scale. What do you do in anticipation of January 1? Well, first and foremost, you just continue to monitor the pending legal challenges. There is a good chance that these rules, at least in part, will be enjoined. It may be that the courts allow for the July 1 changes, but they have a problem there. They have bigger problem with the much higher jump in January 1. And so you could have you could have a situation where part of the rule falls it goes away, and the part that goes into effect early stays. So it's unclear. We don't know what a judge will do. We do know the judges are going to scrutinize this because they did 8 years ago under similar circumstances. So you're going to continue before January 1. You're going to continue to monitor because of this this big jump from currently at 35 up to 58,000 a year. There is going to be a bigger potential financial impact on the company if you're raising people up. So I would suggest that sometime in maybe September, October, as your companies are looking at budgets and operations, you get together your key stakeholders and figure out what's going to work for the company. Because I don't think just raising people up is going to be a solution for everybody. And so if you're not going to raise up people that are under that threshold who are exempt, then you're going to have to account for the hours they're working. You're going to have to account for the overtime. And so there's look at that financial impact. Look at the duties and make sure that you're classifying the employee correctly, because that is the core issue. You never see a case over the salary. You always see it over whether their duties made them exempt, whether they satisfied those white collar rules. And again, whatever you decide as you're planning, you don't implement it until January 1, only if the rule becomes effective. And so that's the quick down and dirty explanation and on this new rule. I don't know if there are questions
Any
on this.
questions for anybody? If you didn't write it in the comments, see the little hand at the bottom? You can raise your hand. You just click it. Heather raised her hand. Go ahead, Heather. Heather, you might be muted. You might have to unmute yourself. And the unmute thingy is at the bottom, the little microphone.
There was a question while we're waiting. There was a question, what are they exempt from? The exemption covers overtime. They're exempt from receiving if you're paid a salary and your duties meet the exemption primary duty test, then you don't have to, the employer does not have to receive overtime. And Janice, I'll send you I saw yours. I'll send you the, you can do a quick search, executive, administrative, professional exemption. You'll come up with Department of Labor worksheets that explain what they are, to explain the test. Be careful. They are legal terms in there that have been interpreted by many courts, and it does require some legal analysis some of the time, particularly on that administrative exemption, which requires it requires the position to have independent discretion over matters of significance, doing office or non-manual work. So, the issue over whether someone has independent discretion is an issue, whether their discretion is over something of significant enough to allow for the exemption. That's another issue. So, but you can find those on the Department of Labor's website, and Janice, I'll send you some. I saw your question. So.
Rhonda, everyone has the able to unmute themselves if they need to now.
Okay, so if we're not unmuted before, you can unmute yourself if you want to ask a question. And we do have some more questions that have come in the chat in the meantime. Skip, does this affect the pay of owners and how we commission only employees affected?
What was the second part?
How are commission only employees affected?
Well, commission only employees aren't covered by this rule. Commission only would be entitled to overtime unless they fit within the outside sales exemption, which is a whole nother half-hour discussion, or the retail sales exemption. also known as Little 7I, there could be exemptions available for commission only, but that doesn't impact the white collar exemptions, which cover the executive, administrative, and professional.
Gotcha.
And then owners, I mean, owners aren't going to sue themselves, presumably. I don't think they will. So, but if they're on the payroll, I mean, technically, your owners, as a practical matter, don't have to worry about complying unless, there's going to be a problem between co-owners, and therefore you should probably get their salaries at least to that minimum level and figure out where that money is going to come from.
Heather, there will be a recording of this. We're recording it, so we will send it out to you. It'll probably come out a couple of days after the webinar. Janice just gave you a plug. Thank goodness you are my lawyer then. So say thank you. Don't.
Thank you.
Okay. Did you see the question from Daniela?
No.
It is, what happens if we have the owner's spouse on the payroll? Would their pay need to be adjusted?
Only if are they working more than 40 hours a week? Because that's the issue, right? If they're working overtime, then you make these changes. If they're always working less than 40 hours and never working overtime, you don't need to make these changes. It's just that if there was a rare week where they work more than 40 hours, you would, there could be a compliance issue if theoretically there could be a compliance issue, but it seems like that would be pretty low risk, considering it's a spouse. So
are there possible fines for not complying? Dun, dun, dun.
Well, there can be an administrative investigation by the Department of Labor. That's less rare than a lawsuit. So what happens is, if you have an employee that's working overtime and is entitled to overtime, they're not exempt, and you owe overtime, that employee can sue you for the lost wages, the lost overtime, plus they would be entitled to liquidated damages equal to whatever that lost overtime is. Plus, they're going to have a lawyer, and the lawyer is going to be entitled to a reasonable fee. And then you're going to hire a lawyer on your side, and it gets very expensive very quickly. A lot of times when you see these claims, if they have any legs, or even if you have just a decent defense, as an employer, a lot of times you're still going to resolve it because you're going to save money in the long run, because the attorney fees on both sides can get out of hand. Yes, I saw. Can part of the salary include commissions? Up to 10% of the salary can be commissions. So you can use up to 4,388 to get them to that threshold. But once the salary is at 4388, then the commissions don't matter until the new threshold goes into effect in January.
Any other questions? James, it looks like you typed something, but I just see a plus sign.
Do we want South Georgia House of Hope? Do we have to do anything to let you ask your question?
You should be able to unmute yourself if you haven't already. You are still muted. So you see at the bottom, you've got the microphone and then the camera. The microphone's probably there. You got it.
Great. I just wanted to ask how you would classify a head chef, because he makes over the threshold in compensation, but he's consistently working overtime. Would that be considered a professional? Would he be exempt from the overtime?
Yeah, a professional, or if he's managing 2 or more employees.
Yes.
And makes hiring and firing recommendations.
Yes.
And yes, that the head chef is usually going to be exempt. Now, a sous chef may not be.
Okay.
Yeah.
Okay. And would you be able to have 2 head chefs that work on different days? I would think so.
Yes.
Or maybe,
Where you get into issues is with assistant managers.
okay,
When the manager is really the one in charge and the assistant manager is not in charge. There's been a lot of litigation over assistant manager positions and whether they have sufficient authority.
okay. I
Yeah.
think I know what to do with that. Okay, thank you.
All right, you're welcome.
And we
So, should we move on?
we can move on. We can
Okay.
catch oops later.
All right. So now that's that one. So now we'll talk about the Federal Trade Commission, and this one also has received a lot of press. And this one, because I think most of us are aware of this particular attempt by the FTC to ban non-competes. It's pretty drastic, right? You're basically changing law that has traditionally been in control. The states have been in control of, and what I mean by that is some states allow non-competes and some ban them. Like California has a ban on non-competes, except for sales of business. And some states have recently. There's been a movement to only allow non-competes for certain level employees and with a salary level and also maybe a duties level. Like Colorado recently raised the bar for an employer to have a non-compete. Illinois a couple of years ago raised the bar. There's a couple other states. So the FTC has basically decided that it has authority to ban post-termination non-compete obligations, and they've implemented this final rule, and the challenges are there. There's indication that there could be a ruling as early as next week on the primary case. But certainly I think we're going to have a ruling on the FTC rule well before September 4th, because there's enough time in the litigation to allow full briefing and allow the judge to make a decision. Whereas the Department of Labor rule came about at the end of April and only allowed for 60 days for the courts to get their arms around the case, and that may not be enough time. So what does the new rule do? You can see it bans employers from entering into new post-employment non-compete agreements with workers, prohibits employers from enforcing pre-existing non-compete restrictions for all workers except high-level policy decision makers earning at least $151,164. That's referred to as the senior executive exemption. We'll talk about that in a few minutes, but it's a very limited exemption. It doesn't cover very many people. We'll talk about that. And then it also requires employers before the effective date, before September 4th, 2024, or basically on or before, but no later than September 4th, employers have to inform workers not meeting that senior executive exemption that the employer will not enforce any post-employment non-compete obligations that are in place. And that covers both current employees and also former employees. Employers have to let them know by September 4th that it's not going to enforce that non-compete. So there's some key definitions in this rule. The point here is that this rule was drafted in a way that makes it very, very broad. And if you look at like the non-compete definition, and I hate to read it, but I'll read it. A term or condition of employment that prohibits a worker from, penalizes a worker for, or functions to prevent a worker from seeking or accepting work in the U.S. where such work would begin after the conclusion of the employment that has that term and condition, or operating a business in the United States after the conclusion of the employment with the term and condition. And what that means is basically any agreement, obligation, or term that prohibits an employee, that prohibits or functions to prevent an employee from going to work for a competitor or from opening up their own business, that type of provision is going to be deemed a non-compete clause, and under this rule, it's going to be banned unless it meets certain exceptions. So a very broad definition, and it could also include you can look at this definition and go, a lawyer working for an employee could certainly begin to argue that non-solicitation clauses also function to prevent a worker from taking a competitive job, right? Particularly if you have an industry with only a handful of customers, and the employee works for a company that maybe has relationships with 2 out of the 4 primary customers. That's a situation where even a non-solicit may be a non-compete clause under this definition. So it's a very broad definition. And then worker is also very defined. It doesn't mean employee. It means, and I've bolded, could be an independent contractor. It could be, I've never seen it, but it could be an intern, a volunteer. They've really, gone out of their way to make clear that worker is just about anybody, right? And so they have said that it does not, that it includes a person who works for a franchisee or a franchisor, but does not include a franchisee in the context of the franchisee-franchisor relationship. So if you just think about that one, the franchisor can still have the franchisee sign a non-compete, and that franchisee is bound by a non-compete, but the people who work for the franchisee are not bound by non-competes. So, I mean, if you can just kind of, as you look at it, you'll see that there's not much business sense to this, and there's a lot of far-reaching implications that this rule has outside of just the overall ban and the attempt to say that it doesn't impact certain relationships. So another key definition is the senior executive exemption, and don't be confused by the term. Really what they're getting at as a senior executive exemption is the CEO or the president of a company. And I'll say that as we work through this definition, but they estimate on their own terms that fewer than 1% of workers are senior executives under the final rule. That's from the FTC. Okay, that's not many people. The criteria is must have annualized compensation of at least $151,000. That's easy to satisfy for most senior executives. But the one that's not going to be easy to satisfy is must occupy a policymaking position. And the reason why that one's difficult is the limitation that they put on policymaking authority. And they say that policymaking authority means final authority to make policy decisions to control significant aspects of a business entity or a common enterprise, and does not include authority limited to advising or exerting influence over such policy decisions, in other words, making recommendations, or having final authority to make policy decisions for only a subsidiary or an affiliate of a common enterprise. So what that means is if you have a parent company, which is the common enterprise, that has 10 subsidiaries doing billions or millions or billions of dollars of business, the heads of those subsidiaries and affiliates probably don't qualify as senior executives under that definition. So it's extremely limited. I would say for small business, it's limited to the owners, right, who don't need a non-compete. So limited to CEOs and presidents, executives making significant business decisions for the common enterprise. And it's going to be very difficult to satisfy that definition outside of that CEO or president. So there are exceptions to the ban, and the primary exceptions are industry exceptions. There are other regulated industries are not. The FTC does not have authority over other regulated industries such as the banking and savings industries, federal credit unions, common and air carriers. And they also do not have regulatory authority over nonprofit organizations. However, recently under this administration, they have gone after some nonprofits to say that they're not really nonprofits. They're entities that are organized as nonprofits, but they're really functioning as for-profit businesses. And in those situations, they're attempting to exert regulatory control over those organizations. So not a lot of, the not-for-profits that we all know, the charitable organizations and organizations organized for public good, those are still going to be exempt, but there are some that are functioning in a gray area that may not be. And then again, I talked about franchisor agreements. They're not covered, but the employees working at the franchise are covered. In other words, they are employer would not be allowed, the franchisee employer would not be allowed to have non-competes with its employees. Other exceptions, and it's important to remember that non-competes are permissible during employment. So you still can prohibit in an agreement an employee from competing while they're employed with you. You just can't prohibit them from competing after employment ends. Again, we talked about senior executives. If you have an existing non-compete with a senior executive, somebody who fits that limited definition, then that's still enforceable. But you can't have a new non-compete agreement after the effective date of the final rule. So after September 4th, even with senior executives, a non-compete would not be enforceable. Non-competes in connection with genuine sale of business, that's allowed, although they want to regulate that in the notes. They do recognize that would be a problem because they would basically impede the sale of a lot of businesses if they allowed an owner to sell and then compete. It would function to make it impractical to buy a business. So, and then this is an important one. If an employer has a cause of action for breach of a non-compete filed before September 4th, then that case is exempted. So if you have an ex-employee that is violating their non-compete, decision has to be made before September 4th to file the lawsuit against that employee. If you don't file it, you're going to lose it on September 4th. You're going to lose that potential claim on September 4th. And then another exception that they've talked about is the allowance for garden leave provisions. So what is garden leave? Garden leave is where an employer will pay an employee to do nothing, right? They will keep the employee on the books, but they're relieved of all their duties, and they can't go to work for a competitor because they're still being paid. But you have to pay them. So garden leave allows, and there are some states that have provisions that require garden leave, but most do not, and most employers are not paying for the privilege of the employee not competing. It is a good idea to consider, and we'll talk in the next couple slides. Garden leave, might be an effective strategy for a salesperson who has significant control over customer relationships, right? You pay them for 6 months to not compete, so that they can't compete, and you you as the employer try to get your arms around that business and control that business, so that when when that person finally ends their garden leave, you've got good control over the business. So it would make sense in some circumstances. So the other aspect of the rule is that it requires employers to communicate with past and present employees that the employer will no longer enforce their non-compete. And so that communication has to go out by September 4th, 2024. And basically it's going to act as notice to the current or prior employees that the company is not going to enforce the non-compete that was in their that is in their agreement that they currently have, or that was in an agreement that ended when their employment ended. It does allow for email notice. I mean, it does make notice, the method of notice fairly easy, by sending it to last known addresses, last known emails. It does provide model language, but, and it's fine. It's a good starting place, but it doesn't, you can imagine that it's not really drafted with the employer's complete interest in mind. And so that language can probably be modified a bit to comply with the rule, but also to be clearer on what the employer is doing and why it's doing it. So strategies, wait on the outcome of the court challenges. I think a lot of people in my world feel like the FTC has overstepped its authority, and depending on the judges in these cases, depending on the arguments that are made, there is a good chance that the FTC has exceeded its authority in making this really drastic change to the way employers and employees interact, and into the way business operates, and also in a way that states have always functioned. Like it's basically taking something that states have been in control of, and it's basically throwing all that out the window. Although it does say that if the state has a more restrictive law, like for example, California bans all non-competes except sale of business, then California law is going to apply. It's not going to trump any law that's more restrictive than the final rule. But we're going to wait on the legal challenges, see what the courts do, and you really shouldn't do anything until you get, until we don't have an answer from the courts, and we're maybe in August, and then at that point you got to consider your communications with the employees, and really, I would say the one thing you can do is look at your restrictive covenant agreements, look at your provisions, make sure that you still have good non-solicitation provisions, you have a strong non-disclosure provision. Make sure that, I would say with non-competes, the typical non-compete has a geographical restriction. Like say, for example, a doctor's office, a doctor's, working in that practice, in that medical practice, maybe is prohibited from working in another medical practice that's within 15 miles. And that type of provision certainly is going to be banned under the FTC rule. But a lot of geographical restrictions don't matter a whole lot as long as the employee is leaving the customers alone. So, look at your agreements, make sure they're doing what they're supposed to be doing, make sure that you can't make them better. And even I'd say better even could be fairer to the employee, in light of the business interest the company has in restricting competition. It's not a non-compete agreement is not always enforceable if there's really no harm to the employer. You can't restrict competition just for the sake of restricting it. You restrict it because the employee has very sensitive information. It can be taken to a competitor and used, or the customer has significant customer. I mean, the employer has significant customer relationships, and those need to be protected. The employee came in, they had access to those relationships. There's a reason for stopping the employee from just utilizing that access and opening a new business, or taking all the relationships that it came to know because of employment to a new employer. So, keep that in mind. It's a good idea to look at those provisions and see if they're really what you need. Consider garden leave. Again, I already talked about it, but consider it for like really critical employees who aren't going to qualify as senior executives. It could be that you just need, 90 days to get your arms around business, and maybe it's worth it. Maybe if you pay, a few months' wages, it's going to, you're gonna be able to control that bit, keep that business under the company's control, and it's, if it could be a substantial amount of business where the money that you're paying for wages is a drop in the bucket. So keep that in mind. Consider retention agreements. If people are happy, or if you have an agreement where they're going to, the longer they stay, the more, they're going to get bonuses, and people will stay. I mean, that might be enough to keep them from going to a competitor. So that's another potential strategy. So what should you do now? We've already really talked about this. This is the last slide. But, monitor those challenges. Remember that the effective date is September 4th. Communicate with employees. So there are employees out there, and there's probably some people on this call that think that non-competes are already banned. Well, they're not already banned. And so, but employees may feel that way or believe that. And so you may need to communicate and remind them that those obligations are still in place, that there are legal challenges to this rule. And, it's always a good idea to communicate effectively with your employees. So you may need to do that. We already talked about reviewing current agreements. And then I think in August, depending on how many employees you have, I mean, if you have tens of thousands of employees that have non-competes, or, including prior employees, then yeah, you better start working on this. But if you have, something that's manageable, then in August, start preparing your employee notices and get everything ready to go out, so that it's either emailed or mailed out, a couple days ahead of the September 4th. But I would say don't send notices right away, because the legal challenges may be successful. And if you've already sent a notice to employees saying you're not going to enforce a non-compete, and then they go and get a job with a competitor, good luck enforcing that. It's not going to be, they're going to have a basis for defeating your enforcement action. And then on that model language, you'll find it on the FTC website. But I would think about modifying it, but be careful in modifying it. But I do think some of that language is problematic. So that is it on this one.
We have a question. Michael has his hand raised.
Okay.
Oh, Steve, my quick question. Are garden clauses, like, when should they be offered to employees, and can they be offered retroactively?
They can be. Where are you? What state are you in?
I'm in Massachusetts.
So Massachusetts actually has, their own provisions on garden leave, but generally they're offered at the inception of employment, right? When they're going to be part of an employment agreement, but you could put together an agreement with those provisions and offer them during employment. I'd have to look, Massachusetts has a little more, there's a few more regulations to sort through. I don't deal with it every day,
Okay.
but it can be done either way.
So they can. So you left 2 months ago. Could they retroactively say, "Here's a garden provision"? Month after you left.
Yeah. Once they leave, they've left.
Okay.
It has to. It takes effect when you've effectively terminated them, but they're still on the books, right? So they're not terminated. They're terminated in terms of their duties. They're relieved of all duties, but they're still on your books as employees, and that's the workaround. They haven't been terminated. That's why the FTC has said that they would allow garden leave.
Yeah. But they have to offer, like, an employer has to offer the garden leave, like, right after the person gives the resignation or whatever, right? They can't wait a month and then.
Well,
them.
You should have I'd have to look at Massachusetts law on that, but you should have a provision in place that gives the employer the option of providing garden leave before the employee gives that resignation. So you're going to want to understand you can have it where it's an option, right? The employer can decide. You get a resignation notice and you say, boy, we better keep this person locked down for 3 months. and you do it. Or you have somebody who you know is not going to impact your business. You can give yourself the option of doing it, but you need to have the provisions in place before the employment ends or before they've resigned. The other thing you can do is offer a separation agreement, but they don't have to accept it, particularly if they have a good opportunity that they're anxious to start.
Okay. Thank you.
You're welcome.
And we have a question from Daniela.
Hi, can you hear me?
Can hear you.
Perfect. I actually had a question, but back to the Department of Labor. So if anyone has questions about this, you can continue and then I'll go last.
No, we'll take it. That's fine.
So when you said that up to 10% of commissions can be used to get them to that salary, does that also include like bonuses and PTO?
No, not PTO and not discretionary bonuses. It has to be non-discretionary income. The easiest example would be commissions that are non-discretionary, right? If they make X amount in sales, they receive X amount in commissions, or an incentive goal that they reach and the employer does not have the discretion to not pay, right? They have to pay it. Like if you achieve X, we pay you Y. That's it has to be non-discretionary. If it's discretionary, where the employer can't just say, "Oh, you're under the threshold. We're gonna just give you $3,000 to make it up to you." That won't work. That does work for a highly compensated, but it doesn't work for the salary.
Okay, so it does. Let's just say we were looking for the highly compensated, could we include the bonuses and all that
You
stuff
can.
onto the?
Yes, but there are some rules that relate to it. In theory, yes, you can.
Okay. And then we work primarily with more medical offices, so does an esthetician consider an HCE employee?
I mean, it's and that is that a doctor, a medical doctor?
It's kind of like a little more of an advanced medical assistant in a sense.
Is there a 4-year degree?
Not a 4-year.
Yeah, no, probably not.
Okay, so more of okay, gotcha.
The professional, because they're providing care, right? Direct care to patients. Yeah. So they have to have a 4-year degree. Like an RN can be professionally exempt, but an LPN with a 2-year, no.
Okay, perfect.
Okay.
Okay. And then what would you consider a professional employee? Somebody that's just managing 2 or more employees?
That's an executive. The executive, I've got an echo. The executive exemption covers employees who supervise 2 or more employees and they make recommendations on hiring, firing. That can be executive. Professional would be somebody who has a 4-year degree and they're working in an area where they're utilizing that degree. So like, an RN is easy. I just said an easy example. There's a 4-year degree. Accounting people who have degrees, who have accounting degrees. Another example.
That's all. I appreciate it. Thank you.
Okay. You're welcome.
It looks like there's no more questions and we are at 2:00. If you do have any other questions, go ahead and email them to Romeo or I and we can get them over to Steve. But, if you need a good attorney, you're looking at one right now. And so feel free to set up an appointment with him if you have any issues or you just want to be proactive. But he gave us a plethora of information today and we truly appreciate you, Steve. And we're so glad that you were our speaker today.
Thank you. Thank you very much, Rona.
And as always, we appreciate our clients. And if you have any questions about other services or anything that you may need, feel free to reach out to us. And I hope everybody has a great weekend, a safe and happy 4th of July, and try to stay cool out there because it's a scorcher. So stay hydrated, my friends. And that means water until 5 o'clock. After 5 o'clock, do what you want.